And establish first, I guess we will establish, Lisa, why don't you read the part of the executive order that allows us to have a meeting electronically, and as I call roll and we vote for that, that'll establish the quorum. Okay.
This is Alex Dickerson from legal. If Lisa doesn't have it, I have that language.
I'm sorry, I was on mute. Here we go. Sorry. We are convened electronically pursuant to Governor Lee's Executive Order number 71 in order to protect the health, safety, and welfare of Tennesseans in light of the COVID-19 outbreak and still conduct essential business of the Metropolitan government. Before we move on with the meeting, the Governor's Executive Order requires a motion to proceed electronically.
Okay, there is a motion. I'll make the motion to proceed electronically. Is there a second?
There's a second, Tom Lawless.
And that's Tom Lawless. As I call the roll, that will establish not only the quorum for the meeting, but also the fact that we will be meeting electronically should all members agree to the motion. And so we will call the question on the motion and vote. Ms. Davis?
In favor.
Ms. Carpenter?
In favor.
Mr. Newton?
Favor.
Mr. Pepper?
In favor.
Mr. Lawless?
In favor.
This is David Taylor, and I vote in favor also. So there are 6 members present at the meeting, and we will proceed electronically. All right. Lisa, are you still muted?
Yes, sir. Sorry. In order to convene this meeting pursuant to that executive order, the board members are participating remotely, and we encourage members of the public to submit comments in support or opposition to the board electronically at bza@nashville.gov. We extended the deadline to submit comments, and any comments received by 12 o'clock noon yesterday, Wednesday, March 17th, were provided to the board for consideration prior to the hearing. Additionally, members of the public can call 629-255-1903 to provide comments in support or opposition to any case called on today's docket. We ask that you wait until the case is introduced prior to placing your call. Good afternoon. The Metropolitan Board of Zoning Appeals is now in session for the regularly scheduled meeting of March 18th, 2021. My name is Lisa Mitten, and I will be presenting the cases to the board for the review in today's public hearing. We are convened electronically. For these hearings, the board reviews the correspondence submitted in support of and opposition to these cases. The board also reviews correspondence and recommendations from other government agencies in preparation for the hearings. In today's hearings, staff will present the site plans, maps, photographs, and other documents that comprise the case record. At the conclusion of the staff's presentation, the appellant will present his or her case to the board. After the appellant's presentation, we will allow anyone wishing to speak in support of or opposition to the case to call into the meeting. During the electronic proceedings, the appellant has 5 minutes for their presentation. Anyone calling in to provide public input will be given 2 minutes to speak. The appellant will then have any time remaining from their initial 5 minutes, as well as an additional 5 minutes for rebuttal for a total of 10 minutes. At the conclusion of each hearing, the board will deliberate and then vote on the case. The board is vested with the power to act on these cases under the provisions of Metro Zoning Code Section 1740-180. All section numbers that we refer to come from the Metro Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The zoning code was adopted by the Metro Council and became effective on January 1st, 1998. I will introduce the entire zoning code and make it part of today's record. The Metro Zoning Code requires a record of these proceedings. Because BZA meetings are recorded for Metro Nashville Network, it is imperative that anyone addressing the board identify themselves by name, address, and then make the desired presentation. The Metro Code requires 4 members of our 7-member board to establish quorum. The code also requires at least 4 affirmative votes to grant an appeal. In the event that 5 or more members are present, but the appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days the public hearing shall be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal board decisions to Chancery or Circuit Court within 60 days of the entry of the BZA order. Additionally, as per the BZA rules, an aggrieved party may file a motion for rehearing by the BZA within 60 days of the original hearing date. After that time elapses, the board's decision becomes final and no further action can be taken. If your appeal is granted, you're required to obtain the permit for which you applied. A permit must be obtained within 2 years for board approval to remain valid. It should also be noted that if false or misleading testimony is presented to the board, any board approval could be revoked at a later date by means of a show cause hearing before the BZA. Mr. Chairman, I submit that all cases have been filed in proper order. All appellants have been notified by certified mail and all legal notice requirements have been fulfilled.
Great, thank you.
Mr. Chairman, I do have preliminary announcements regarding deferrals. Case 2021-035, located at 922 Morrow Road, has been deferred indefinitely. Case 2021-047, located at 265 Broadmoor Drive, has been deferred to the April 1st meeting. And case 2021-049, located at 3418 Hampton Avenue, has been deferred indefinitely.
Okay, thank you.
We are now ready to proceed with the cases to be heard.
Okay, first case.
The first case to be considered is case 2020-043, located at 4109 B Murphy Road. This is an item A appeal challenging the zoning administrator's issuance of a building permit within an RS75 district. Here's an overview of the zoning of the parcel, the aerial view, the proposed development, and the existing site. Before the applicant addresses the board, the zoning administrator would like to read a statement into the record.
Mr. Chairman, John Michael, Metro Zoning Administrator. Of course, at our last meeting, we heard the motion to defer on this case, and in so doing, heard a lot of the some of the details that are at issue now before the board with the actual case in chief, the item A appeal. Short version is this. After having originally determined upon our review of the evidence that there was sufficient evidence to demonstrate likelihood of maintenance of legally nonconforming use for two-family at 4109 Murphy Road, we have since received more information, specifically documentation from a Ms. Jody Chips Eastgate, an email from her from late February that specifically addressed some of those questions in the timelines where we had less information. With that, I can tell you affirmatively that that would have reversed my prior determination and, in fact, would have never resulted in this permit having been issued if we had had that from the word go. It's okay that that was not the case, but now that we do have that information, the question before the board on this item A appeal is, was the zoning administrator incorrect in his determination that the property was, in fact, eligible for two-family construction based upon legally nonconforming two-family use? My proposed answer to that question is yes. Yes, I was incorrect. And I now know that because I have more information toward that question. So I can tell you that yes, I was wrong, but this case has been properly noticed, filed, styled, researched, lawyered, etc. And therefore, it's best for the board to hear the case and see what you agree with based upon the presentations made to you today. Although I'm happy to answer any questions, I think that's a pretty succinct overview of the city's position with regard to the matter.
Are there questions for the zoning administrator? All right, thank you, Mr. Michael. And so the way this works is that we will hear from the appellant, and in this case, it's the two neighbors that have appealed the original decision from the zoning administrator, I believe, Ms. Nickens and Ms. Rands, who we heard from at our last meeting. And then we'll have an opportunity to hear from the property owner and or his representative. And then if there's, I think, additional comments from the public, there'll be time for that. Is that right, Ms. Minton?
No. 31. This is actually Ms. Shepherd. Ms. Minton, are you able to address that, or are you on mute?
Please restate your question.
No, I mean, the order that we'll hear this is that we will hear first from the appellant, who are Ms. Rands and Ms. Nickens, and then we will hear testimony from the property owner and or the attorney, and then we'll have the public call. Is that the order?
Ms. Shepherd, ask Ms. Shepherd to respond to that. She's got the.
Confirm Ms. Shepherd has the correct order and sequencing. We can confirm with Ms. Shepherd, please.
It will be, the appellant will start, they'll have an initial 5 minutes, or they can use part of their combined 10 minutes and save some for rebuttal. Then we'll take all callers, and then the Mr. Henry or the property owner will have an opportunity to speak, and then the remaining time for rebuttal can be used by the appellant.
Okay, so the first up, we will hear from the appellant. Is Ms. Nickens or Ms. Rands with us?
There, you're unmuted.
Oh, great. Hi. Can you hear me? Ooh, it's making that.
That's yours. You got to mute yours.
We can hear you, and if you would please mute your computer or whatever you have there, so that we can hear you without feedback.
Okay, can you hear me now?
Yes.
Wonderful. Before I get started, I wanted to let you know that John Summers will be participating in the rebuttal. Can you hear me okay?
Yeah, we're getting some pretty serious feedback from you. So if you can mute your phone or your computer or whatever however you're listening to it, we're getting some pretty bad feedback.
I think you have to keep this muted while you're talking.
Okay, can you hear me now?
But you can't hear them, so you just have to talk.
Yes, we can hear you.
Here's how it'll help.
Except because mine's muted, but we can try.
Okay, so sorry about that. Can you hear me now?
Yes.
Okay, great. Okay, so before I get started, I just wanted to let you know that John Summers will be doing the rebuttal, in case everyone was not aware. And sorry for the delay. Good afternoon. My name is Lindsay Nickens, and I'm one of the three appellants. As Backway, I'm the homeowner of the property next door to 4109 Murphy Road. I'm a native Nashvilleian and multi-generational family homeowner in Sylvan Park. The appellants are challenging the zoning department's decision to issue permit number 2020-0517668 4109B Murphy Road to allow a horizontal zoning regimen. 4109 Murphy Road used to be one property and should remain that way. In our opinion, grounded in evidence, humbly, the department made an error in granting this permit, and this is why the appeal has occurred. Although misleading white page online documentation was submitted to codes to prove that 4109 Murphy Road was used as a duplex, this is simply not true. 4109 Murphy Road has not been used, that's the optimal word, as a duplex in over 18 years. Former landowners, Mrs. Jody Chips Eastgate, who lived at the property from 2007 to 2020, that's 13 years, as well as Miss Susan Chambers, who lived there from 2002 to 2007, that's 5 years, totaling 18 years in total, clearly attested in letters to the BZA that they used 4109 Murphy Road as a single-family home. I personally spoke with Mrs. Chambers, and her statement, which the BZA received, remains the same. Becca Rands spoke with the entire Eastgate family and can answer any additional questions. They all verbally attested to what Miss Jody Chips Eastgate, as well as her daughter Caroline, wrote to the BZA, stating it was a single family use. In addition, licensed real estate agent Kate Cook, who represented the sale from the Eastgates to Mrs. Ramsey, helped me personally tour the property and told me the house was a single family home and verbally told me it had lost its designation with codes based on how the Eastgates used the property. BZA BZA, you should also have Kay's email. Based on this, there is no legal evidence to determine there was a duplex on this property to then allow for the parceling of land based on the nonconforming use laws of Metropolitan Code 17.40.50. You will hear from Mr. Henry today. Mr. Barr was an unknowing buyer, that he used marketing and advertising of the property, which he sent to the BZA from former homeowners and real estate agents in order to make his investment decisions. That he had no way of knowing that 4109 had lost its nonconforming use status and that he should not be held responsible. With all due respect, Mr. Barr is a speculative developer and real estate investor, and his wife is a real estate agent that owns 5 properties in Sylvan Park alone, not to mention those outside of Sylvan Park that are duplexes. In fact, it appears in our opinion that Mr. Ramsey and Mr. Barr were in collusion. Ramsey flipped the property 4109B to Barr one day after the permit was issued from Codes in early June 2020 for the low amount of $50,000. I even have a text from Mr. Ramsey confirming his buddy Brad was on the property. Apparently, in hindsight, Mr. Barr was scoping out the back lot on ways to build a house. You also have an email from Susan Fennell dated March 3rd, 2021 that I encourage you to deeply read. She is referencing the Sylvan Park neighborhood experience with Mr. Barr during the zoning appeal of 4404A, B, and B Westland Drive, where she states Mr. Barr was made fully aware of any and all duplex zoning requirements. Moreover, Mr. Fennell felt he strongly misled the BZA on his intentions for both the current home and the new construction, both in its intended use and structural components. And so if Mr. Barr was such an unknowing buyer that should not be held responsible, I humbly ask this council, why would Mr. Barr start construction after he was notified by the BZA of the item A appeal and his monetary responsibility should he continue to make expenditures on the property? I have pictures with dates from January 27th, which is after he was notified, through February 24th, showing construction crews working on the property, actually breaking ground in the back, and can provide additional details if needed. Last but not least, this whole project negatively impacts our quality as neighbors, and we will still have concerns about the flooding and fire issues. I could not imagine a 4-alarm fire going back in the backyard, and his building plans submitted do not appear to match what is happening, specifically the footpath bridge, which appears to be a large driveway. In conclusion, based upon the evidence presented and the law, we would respectfully ask you to approve the appeal in case 2021-043 to revoke this permit, reinstate the property as one piece of land, and cease all construction activity. Thank you so much for your time. If you could please let us know how much time we have left, I'll turn it over to Becca. Otherwise, she'll be calling in at a later time.
Ms. Shepard, how much time is left for the appellant?
There's 5 minutes remaining of the 10.
All right, 5 minutes total of altogether. Ms. Rands, would you care to speak at this point?
Hi, I'm here with Lindsay. I don't know why there's feedback now. Anyway, I don't.
Yeah, ma'am, we're getting the same type of feedback we got a minute ago.
Strange. Is that better?
Yes.
Okay. I don't think, I don't know. I think I can skip it for now. I feel like Lindsay covered most everything closely to what I would have said. So.
And we would encourage you to ask her any questions specifically as it relates to the Eastgate verbal conversations, if in fact they want to attack the witnesses. Thank you so much.
All right, are there any questions for the applicants from the board? All right, seeing none. Ms. Shepard, do we have people on the line?
We do not at the moment. I would say let's give it a few seconds to see if they start calling in now that you've asked them to.
Okay. We'll give a few minutes or a minute.
Mr. Taylor?
Yeah.
I just got an email from Mr. Pepper. I don't know. I think he might have lost his audio.
We have him back on the call now.
Oh, good. Great. Okay.
He's just not going to appear, his name is not going to appear as a panelist at the time, but he is on, he's going to be able to participate.
Yes,
Thank
can
you,
you hear me now?
We can.
Okay. Yeah, we've lost our internet connection here downtown, at least in our building, so sorry.
Okay. And Mr. Pepper, if you do have a question, I don't see you. I don't see you. So if you have a question, just jump in and, at a break and, in the conversation and say you have a question.
Okay. I'll rudely jump in without raising my hand like I normally do.
Okay. And also as we, just while we're waiting on callers, I do see on my screen that our board member Joseph Cole has joined us, and I believe was here for the entire hearing. He was on the attendee list, and I think now he's on the board list, and that was based on a technical difficulty. So if you would just announce your presence, Mr. Cole, to have that on the record and to establish that you were here and you've been here for the entire case.
Yes, I am here, and I've been here for the entire case.
Great, thank you. So just wanted to make sure when we got to discussion and in voting that it was clear that you had been and are a full participant. So welcome back. And Ms. Shepard, is there anyone, has anyone called in?
We have Councilmember Murphy on the line.
Okay. Council Lady Murphy? Is Council Lady Murphy live with us now?
We are working on it. Thanks.
Okay.
Mr. Taylor, I think we're having some technical difficulties today.
Okay, she is ready.
All right. Welcome, Council Lady Murphy. This is David Taylor. Glad to have you here.
Great, thank you. And I apologize. I actually missed the presentation in the beginning because I was having difficulty with the Metro website. And I did want to let y'all know that the number popped up after you had asked for callers. And so I don't know, something just isn't synced up there. But anyway, thank you for letting me call in. This is Councilwoman Kathleen Murphy, District 24, 231 Orlando Avenue. And I believe that y'all have my letter from the previous meeting, but I just wanted to call in and reiterate that I think this case is pretty clear cut. You have letters and witnesses before you and turned in that can testify and verify that this property stopped being used as a duplex. It is clear from previous owners, regardless of what their real estate agents may or may not have put in listings, this property was simply not used as a duplex and therefore lost its non-conforming, its non-conforming use status because it was zoned to a single family and then the use was stopped. And that's what is important here. You all have taught me nothing else over the last 6 years in office is that the use has to continue, that the bells and whistles can be there. I mean, putting a board in a mailbox is simply not evidence that it's continuing to be used as a duplex. And I think that the neighbors here have been very diligent. I think that when it comes to our budget time, that we need to discuss how to get codes more sneaky yet again this year, because we shouldn't have the neighbors having to fight amongst each other to figure out what the proof is on these permits. And clearly, the zoning administration didn't have enough time to research every case. But I think here there has been plenty of evidence given to y'all to show that the use was discontinued and discontinued long enough to lose its status to be a duplex. So regardless of what the property owner now knew or didn't know, at the end of the day, the status isn't there. I'm sorry they made a bad investment and wasn't comprehensive enough, but I appreciate that my neighbors have and my constituents have been able to do the work that should have gone into this before this project even started. And so that I just ask that y'all, hold firm that this permit is invalid and should be found that this is clearly a single property, a single dwelling, regardless of what it may look like. It is a single family property at this point, and that's all it can be for. So I'm happy to answer any questions. I can either stay online or call back in if you need me to. And Chair, I'm just at the will of your committee.
Great. Thank you, Councilor Murphy. And you know what? I know I've been on this board for a long, long time, and this is certainly an anomaly. You don't hear this type of case very often. And what you may have missed at the beginning was the zoning administrator explaining the situation and noting that based on the case file as presented to us today, and of course we haven't had an opportunity to hear from the property owner, but based on the case file, he said that it would most likely not be issued. But again, this is the proper place for us to determine it. And so, again, I think it is a strange anomaly that kind of we're dealing with today based on information that came to us after the permit was issued. But we appreciate you and everybody in the neighborhood kind of finding out information that they've had to complete the case file that we have.
Well, good. It sounds like hopefully y'all are on the right track, and I'll listen to the rest of it on my laptop. And again, if y'all need me to hop back on, I'd be happy to.
Great, thank you. And let me double check, make sure, are there any other questions for Council Lady Murphy? Okay, I don't see any, and we sure appreciate you being here.
Great, thanks y'all. Have a good day.
You too. Ms. Shepherd, are there any other callers?
No, sir.
Okay, then we'll hear from the property owner and or his representative. I don't know if that's Mr. Henry.
Yes, sir. I'm here if you can hear me.
We sure can.
Excellent. Well, am I free to proceed?
Yeah, I think so. That was Jessica. Did you have some?
Mr. Chairman, can you clarify how much time the property owner is being given?
Well, I thought that the other side had 10 minutes, right? So wouldn't the property owner have 10 minutes?
Thank you. That's all I needed.
Okay. Yes, sir. Mr. Henry, proceed.
Thank you. So, Mr. Chairman, members of the board, I represent Brad Bars. He's the purchaser of Unit B. I filed a letter on March 17 that is about 3 pages, mostly 2 pages, contains some photos, contains some other documents. I hope you all have had a chance to look at that. We certainly submit that as substantive evidence for your consideration. Let me give you just a little bit of background here first. The two appellants, as you know, live on both sides of 4109 Murphy Road. Appellant Lindsay Nickens, who you just heard from, bought her property in July of last year. She bought her home after my client had purchased the property. But she also bought her home as a duplex. Her property is recognized by the assessor, recognized on the Metro parcel records, and classified as a duplex since 1999. That's the home on the left. That was just on the screen, but seemed to drop off. Appellant Ms. Rance, who's also on the call, she bought her property in 2019. The point is this: both of them knew or should have known by a quick look at the Metro parcel viewer records that this property 4109 was a duplex. They were absolutely on constructive notice. To suggest anything otherwise really just does not smell correct. Presumably, this upstairs apartment, as referred to by the prior owner, Jody Chips Eastgate, she referred to this as a mother-in-law suite, but apparently it wasn't a concern to either of the appellants when they bought their property, and that's likely because the apartment was contained within the 4 walls of this house. But when they learned that a new home would replace the attached apartment and would be built deeper on the lot in their clear view from the back of their home, they mounted this objection. So that's what this is all about. This is not about whether or not it's a duplex or not. It's about their concern can be drilled down on the fact that they don't want a new home built on the back of the property where they can see it from their property. If the home were attached, I think they would probably have a different perspective on it. Murphy Road, the Murphy Road neighborhood. This entire area was zoned for duplexes under the prior R6 zoning district from 1974 to 1998, okay, under the comprehensive zoning ordinance. This entire area is filled with duplexes. With the adoption of METSO, the current zoning code in 1998, this area was downzoned to RS, single family only. And that zoning change made many of these duplexes legally non-conforming, including the one on this property. In fact, according to Metro Parcel Viewer, there are 13 duplexes and 1 triplex fronting Murphy Road within this short segment of street between 40th Avenue and 44th Avenue. And I want to just give you those addresses real quick. There's a triplex at 4001 Murphy Road. Duplexes are on the rest of the street here: 4006, 4012, 4015, 4026, 4102, 4107, 4109, 4120, 4124, 4128, 4201, 4200, and 4305. I just looked that up this morning to see all these duplexes. So the issue really is not so much the fact that they're trying to return the property to 2 units. It's the fact that they're putting it in the backyard. 4109, this property was metered by NES for a duplex use in 1984. The duplex was legally conforming for 14 years. And then in 1998, it became legally non-conforming, and it has maintained that legal status for the past 23 years. Now, the prior owners, you received 2 emails from 2 prior owners and the daughter of one of the owners. So you've got 3 emails talking about how they use the property. But however, both of those prior owners maintain the duplex classification per the property assessor's records, which we've supplied to you, as well as the Nashville Electric Service records. So neither of them ever challenged the appraisal, and I've looked for those records, but there's never been a challenge to the appraisal of the property as a duplex property. They've never relinquished either their NES, either meter that was installed by NES. To the contrary, they both have actively marketed the property as having income-producing rental options. They never changed the city's duplex designation, and they each profited by selling their property as a duplex designation. So we get to this issue of rent. You have 2 emails from the prior owners that say, we never rented the property. We never rented it out. We never collected rent. That is completely immaterial to whether the property is occupied at any time as a second unit. Whether Ms. Eastgate actually collected rent from anyone is immaterial. She considered it a mother-in-law suite, according to her own email. A mother-in-law does not normally pay rent, nor does a child normally pay rent. We know her child lived there. So the lack of rent payment does not mean that the prior owners had abandoned the apartment. In fact, they absolutely did not abandon the apartment. Their own MLS records prove that. One can occupy a unit, as I said, without paying rent. Finally, once the site plan was approved in this case and the permit was issued, the property attained a vested right to continue with the building permit. I want to get that on the record. I think Mr. Barr is available to answer any questions. I think he's got some comments that you should hear as well about his investment in this property. I'd like to know how many minutes we have left, if we could, since we don't have a meter. Thank you, sir.
You have 4 minutes remaining.
Are there questions right now for Mr. Henry? So if you have, Mr. Henry, if you have a prior owner that said, I believe in her letter, and I think that's Ms. Eastgate, saying that they never used it as a duplex, and that the access was internal, and they basically had their bedroom up there. Help us understand your argument better. I mean, I think you made a good argument, but I just want another summary that says, you know, that proof of a duplex is simply somebody living in it, not rent, not leases, not anything else that we might think of as additional proof.
Yes, sir. So her email says that we did not rent out any portion of the house, and that we considered the upstairs to be a mother-in-law suite. Well, the key is how it's being used, not whether somebody else is coming in to pay them to use it. It's how the property owners are using it. And we have found in the public records that the East Gates filed for divorce in 2018. I understand that divorce proceeding is not complete, but I am told, and I understand this is hearsay, but I'm told that upon the filing of that, those papers, that they lived separately from one another within the same home, in the separate units, that they lived separately and used the two units independent of one another. Now, you know, it's the same family, but they were in a proceeding and separating. So again, the question is, and my client, of course, came along at a later date and is trying to see sort of how this history has all played out. But the bottom line is, they can say we didn't collect rent. They can say that we didn't have anyone from the outside come in and use it, but they used it as such. They used it and they maintained the designation as a duplex. They paid real estate property taxes as a duplex. They paid meters, and the meter records indicate that the drawdown on the electric service were normal. Okay, that they were. You can read that in the document that the drawdown of the electric use was normal. That's the classification in the ESUs. So the point is, it was actively being used. They did not abandon the apartment. They did not abandon the mother-in-law suite, and therefore they did not abandon the use of the property as two units.
So, Mr. Henry, this is Mr. Pepper. I have to butt in because I can't raise my hand. I'm not able to do that. My system is down. But, you know, I'm with you about the rent. How did the use ever become multifamily? I mean, maintaining a mother-in-law suite is not maintaining a multifamily units. And, you know, with respect to the designation as a duplex, you know, there are, I'm sure, a lot of properties around town that the tax assessor has designated as duplex, and people don't bother, even though they're not using them as a duplex. Why would they bother to have that designation changed? And with respect to the 2 meters, do you have any information? Well, let me ask you this: wouldn't it have cost? My understanding is, if you want to change the number of meters you have, whether to go from 1 to 2 or 2 to 1, you have to pay a private electrician, and that can be fairly expensive. So wouldn't that be a reason that someone would just maintain 2 meters if there's no expense to doing that, but there is expense to changing that?
Well, I'll start answering that in reverse order. The motivation to stop paying for electric service that you're not using is to stop paying a monthly fee, a monthly charge, service charge that they were getting from NES in order to use the unit. So the motivation there is to stop paying for something that you're not using. They didn't do that. Secondly, on the duplex designation, one would appeal the appraisal of a property to the property assessor if in fact they have it misclassified and therefore they have it valued greater than what the property should be classified. So in theory, the appraisal would be less if the property were single family only. The appraisal from Metro is higher when property is designated for dual use, for use by 2 families. So it's more valuable, and thus you're paying more taxes on it. So why pay more taxes on a piece of property that you're claiming isn't supposed to be a duplex, when in fact it was that way since 1984?
Well, I'm with you there, but could it just be that somebody didn't want to go through the hassle of the reappraisal process and go down to the Metro office you go down to and go through that? And I mean, is it necessarily so that the duplex would be valued that much higher by the property appraiser?
Well, all you have to look at is the MLS records that we supplied as Exhibit 3 to what we gave to you all the other day. Each of their real estate marketing materials detail the fact that this property is valuable because it has either an apartment or it can be rented, the basement can be rented out, or the back lot can be built upon. I mean, these folks who are saying we didn't use it as a duplex didn't want to relinquish the designation of duplex because it did make their property more valuable, and they were able to sell it to successive buyers at a premium because of that duplex right, because of that right to have a duplex. My client comes along, buys it and wants to use it in a different form. It's still a duplex. He's not proposing to do anything that wasn't previously permitted. Wants to continue how it's been treated all along, but because it's going to be a new building, it's going to be detached. The neighbors don't want to see a building where there's not been one before.
And Mr. Henry, I'm with you there. I understand you're saying that the prior owners wanted to maintain the status as a duplex, and I can understand why that might be true. But is our question whether the status was maintained as a duplex or whether it was actually used as a multifamily duplex?
Well, that's exactly right. So the issue is, I mean, I had to address two things in this awkward hearing that we're having over the telephone. I had to address the challenge. There's been two challenges. One, that this property was never a legal duplex to begin with. That's absolutely correct based on what we have submitted to the record. Secondly, if it is a legal non-conforming duplex, was there an abandonment of its use for 30 months or more, for a period of 30 months? And what I'm pointing out to you is, despite what the prior owners are saying, we didn't collect rent, they continued to use the property and hold the property out as a duplex. And based on the proceedings we've looked at that are public records, it indicates they continue to use it and live in all of the spaces that were served by two separate electric meters. And so, you know, if they didn't want to do that, you would disconnect one meter and stop living in that area of the home that's electrified by that particular meter. They never did that.
Okay, I appreciate it. Thank you.
Are there other questions right now from Mr. Henry? Okay, and then Jessica or Lisa or John, remind us. I think that the applicant has a right for rebuttal. That's the neighbors. Is this Mr. Henry's last chance to speak, unless there are questions specifically for him from the board?
Yeah, there's 4 minutes remaining for Mr. Henry or Mr. Bars, and that will be their last turn to speak.
Okay, so I guess, you know, again, item A's are confusing, especially when we've got a lot of people on both sides of the case, and so it usually is a kind of a three-prong approach. You have applicant, opponent, applicant, and so it usually, I'm not sure when. I just want to make sure Mr. Henry has the chance to say everything that he wants to say, and that we kind of don't go out of order. And like I said, it's odd. This is an odd case where you have usually the homeowner is the applicant, and in a case like this, an item A, the homeowner is not the applicant. So next up, we would hear anybody calling in to support or I guess we have already heard all the callers that we're going to hear, right? If they call to speak one way or the other, they were supposed to have called, and that opportunity has been given. So we hear from the applicant now, then do we hear again from Mr. Henry?
Sir, yes, we have 4 minutes as I understand it, and I'd like for you to hear from Mr. Bars.
Yeah.
Okay. Oh, I'm sorry. No, I'm sorry. But you all are still in your presentation. That's what I meant. I'm sorry. Mr. Henry, continue, and Mr. Bars, yes, please continue.
Mr. Bars, you should be able to speak. You're unmuted. If you're speaking, we can't hear you.
Mr. Chairman, while Mr. Bars is trying to, are you there?
Yes.
If Mr. Bars, I don't want to lose any time here, but let me speak to part of what he is going to speak to, and that is, the expensive effort that he's expended here in this effort to build a home, not only to buy the lot, to build a home on here. We haven't submitted this in writing, but I can tell you I've got a list here, and Brad, you there?
Yes, sir, I'm here.
Take over, Brad. Take over. You got limited time. Thanks.
Oh, awesome. So I just want to correct a few things. I'm not a speculative developer. I am a Nashville native, own over 100 properties in the core here. So we really care about Sylvan Park. Speaking on my character, Sylvan Park Restaurant was owned by my family. So we've been in Sylvan Park for a long time here, and we really care about this neighborhood. But going back to the facts of the case, when I purchased this property, I got the permit issued. I did everything that was requested by code to be compliant. I got the affidavit signed showing in 98 that it was, occupied by 2 separate parties, and since have, gone with that information to proceed with building. So since I got my permit, I've incurred, probably about $160,000 worth of improvements to that land, and so I've proceeded with the utmost integrity of the city. I went through the proper protocol to get, the permit. I got what was requested by the, zoning examiner. So I went about that way. And then once I got the permit, we proceeded as asked. And also, I might say that, when this property, when I analyzed it myself, when I was looking at it, the stairs on the side were a completely separate entrance. There were 2 meters. There was the door interior was able to be closed, so there was 2 separate dwellings. And so I want to say that, doing my own due diligence on the property, when I went upstairs to look in that second kitchen, it was a gentleman's stuff upstairs and a woman's stuff downstairs with a ton of Amazon boxes. And upstairs, the kitchen was being used. There was actually fresh food in the microwave upstairs. Clearly someone had been there. And this is when I walked through the property to make sure that, it was wise for me to purchase that back lot. So
2 minutes remaining.
Yeah. And so what I want to say is, I believe I did everything to be compliant. I've spent over $160,000 on this project based on the permit I was issued. And I am also, a proud member of Sylvan Park, do a lot in the neighborhood to make it positive, have a lot of history here, went to MBA, so we golfed at McCabe. So anyways, that's a moot point. But my point being is I've been compliant. I did the cost. For my visual, there are 2 separate dwellings. And just going back on one other thing that Suzanne Chambers did say is that Rudy Title will corroborate, Laura Mitchell, she may even call in, that there was people that lived in that upstairs dwelling through Suzanne Chambers' ownership. So I think there's a lot of things here that are being stated that may not be accurate from the appellant. But I will say this also to the board. I'm willing to work with them. I understand that it's kind of different to have a front to back house. But people do the side by side in Sylvan Park all the time, but I'm willing to work with them if that's something, because I firmly believe that this was a duplex the entire time, just as Mr. Henry stated, and I'm willing to work with them. If it's something that's a smaller building back there, something that makes sense for them, that's something I'm open to, but I firmly believe that this was a duplex based on my own visuals findings, based on talking to a tenant that lived there during Suzanne Chambers' entire ownership. And the Eastgates have a whole different thing going on that I personally don't want to talk about other people's personal business, but that is something that has to be considered. And, you know, Rudy Title will corroborate that she knew the tenants, or Laura Mitchell at Rudy will corroborate that she knew the tenants there during Suzanne Chambers' ownership. So there's a lot that's going on here that maybe it seems like it's totally one-sided, but if you were in my position and saw what you saw and heard what you heard from some of these tenants with Suzanne, then I think it was a wise decision to buy the lot based on what the zoning code gave me as well.
Your time's up.
Are there questions for Mr. Bars? Yeah, and I guess the only question, Mr. Bars, you mentioned tenants. I don't see anything from you all. I mean, it sounds like, I mean, it sounds like you had asked, were there tenants, and someone said, yes, there were, but there's nothing that I've seen that is said, and help me if our packet is very, very large, but I don't see anything that says, hey, I was a tenant, or here are the folks that I know were tenants. Am I missing that?
Sure. Yeah, I got this information yesterday afternoon, so I'm hoping that Laura Mitchell will call in if she has time today to corroborate that from those tenants, because she's friends with some of them that live there, and it's just a case of getting information that past the deadline. But I will say that I believe that the information is correct, but it's trying to get her to call in.
Mr. Lawless?
Yeah, actually, I've got a question for Mr. Henry when we finally get back to him, Mr. Taylor.
No, it's fine. You can ask either one. It's their presentation now. So and
Mr. Henry, this is Tom Lawless. I noticed that you all steered clear of the vested rights side of this. I was just wondering, are we going to hear any of that, or are you fine with just knowing that that's out there for some of us?
Yeah, no, sir. I did not mean to glean over that. I did mention that in my presentation, that we believe that, again, that once the site plan was approved, once the building permit was issued, that under the state Vested Property Rights Act of 2014, that this property attained a vested right to complete the construction in accordance with the permit that was issued. That we think that is completely in play here, and excuse me, and frankly, I don't believe the zoning office made a mistake here, made an error in any way. They can only perform based on the information they have in front of them, and all the information that everybody had was that this was a duplex. Only after the fact are people trying to suggest otherwise. Thank you.
Thank you, sir.
Any other questions for Mr. Bars or Mr. Henry? Okay, and Ms. Shepard, I think you said that their time was up?
Yes.
Okay, so then we'll now hear back from the applicant. And how much time is left for the applicant?
5 minutes.
All right, so 5 minutes in total. Okay, and so
Just say John Summers.
Hi there, John Summers will be speaking. Thank you.
Thank you, Mr. Chairman, members of the board. I'm John Summers. I live at 5000 Wyoming Avenue since 1991. I'm here on behalf of the Sylvan Park Neighborhood Association, and we have voted to support the applicant's appeal here on 4109B. First, I want to say I concur with your zoning administrator that this permit was issued in error. There's no evidence, none whatsoever, either in the records that the zoning administrator submitted to everyone or in Mr. Henry's presentation, that this property was ever legally permitted for a duplex when it was allowed to, when it was R6 zoning. There's nothing in the record that this property was ever legally permitted. So if it was never legally permitted, then there was no non-conforming use that was transferred to it when the property was downzoned to RS 7.5. So there was an opportunity for this to be a duplex. It wasn't legally converted to a duplex. There's no permit, so those rights never vested. Even if they were there as non-conforming uses, that was lost over an 18-year period of time. And you have two property owners that have testified to you. You know, they get to testify to their facts, not Mr. Henry. And so they have testified to you, and you have corroborating evidence on the east gates. We have one resident with 7 years in the property, and one with 11, I think, or 5 and 13. Excuse me. But they have testified to you that they did not use this property except as a single family residence. It doesn't matter how it was configured. It doesn't matter what was there or what wasn't there. If they say they used the property as a single family residence, then they used the property as a single family residence, and there's not evidence to support otherwise. So we would respectfully, state that even if there was a duplex non-conforming use there, it was lost under both 1740-50B of the Metro Code and 1740-50C Section 1. So those rights, if they were there, which we say they were never there, never legally there. You know, we have a lot of real estate investors, and Mr. Barr admitted he owns 100 properties, so that makes him a professional real estate investor in this community. You know, they're out there trying to put the square peg in the round hole to make a more of a profit where they can find these properties that are in limbo. But the truth of the matter is, Metro required you to have a permit to convert a single family residence to a duplex. And if you didn't get that permit, then you were not legal, regardless of the number of meters, mailboxes, or outside entrances. As to the vesting issue, there's no vesting rights if there's an illegal issuance of a permit. Metro cannot grant a power that it does not have. It cannot grant an illegal use. And once you have a conforming property, it has to comply with the regulations that are in existence. And so this property has been RS 7.5 since the late 90s, excuse me. Part of the neighborhood was downzoned with COMZO. Part of it I downzoned later when I was councilman for this neighborhood. But there is no non-conforming use existing here. It was never legally permitted, and so the Metro government erred in granting the permit, which it did not have the power to do. So that permit was null and void. And
minute and a half.
I'm glad to answer any questions. Be glad to answer any questions, or defer my time to Ms. Nickens if she needs it.
Mr. Lawless, did you have a question for Mr. Summers?
Sorry, I forgot to take my hand down.
Okay. Are there any questions from the board at this time? Okay, I see no questions, and so I think there's a minute and a half left for your presentation.
If Ms. Nickens would like to say something, again, I just reiterate, this was never legal non-conforming use. We would ask you to support the ruling that you've now had from your zoning administrator. We believe that's proper in terms of the law and proper in terms of the evidence.
I would also like to add, again, just to reiterate that when I was looking to buy property, bought my grandparents' house, I actually looked at property in question, and the realtor stated it was a single family residence and that the homeowners at currently the Eastgates had lost its designation. Verbally, she told me this. When I was looking to buy the property, I also toured the property. And I can certainly happy to answer questions around that. I really don't think that we should get into the laws of separation. Technically, they were not divorced. They were living in the same house together. There was a bedroom upstairs that I actually visually was able to scarcely make it up to. And I also just want to state again, for the record, that even after Mr. Barr, I made certain that Joey Hargis contacted Mr. Barr just for this reason about the investment, the monetary investment. And he continued, and I have pictures of what the land looked like. And the pictures date from January 27th, 2020 to February 24th, 2020. where he was doing most of his significant, quote unquote, significant construction. This is after he was made well aware from Mr. Joey Hargis of codes. So while we, certainly want to understand that, this is part of being an investor, a speculative investor. Sometimes you make a bad investment and you lose your money, unfortunately. And I think that's all. I think we're asking you to do what's in the eye of the law, the way the property was used. Even if they have someone step forward around Susan Chambers as quote unquote renting out a studio, that doesn't really qualify even as a duplex. And that was 17 years ago or something. So we're like, then let's look at the Eastgates. And the Eastgates lived there for 13 years. Thank you.
All right, Mr. Lawless, did you have a question now?
Now I have a question, and in this instance, on the proponents, how reasonable was it for the owner of the property to rely on the erroneously entered or submitted permit to his detriment of around $150,000 to $200,000 in expenditures that he had? And please don't assume from my questioning, both of Mr. Henry and yourself, that I've made a decision one way or the other. I'm just trying to get a feel for what you think is fair also.
Who are you directing the question to?
Well, I'm directing the question actually to Ms. Nichols or you sometime, either one.
Could I respond?
Folks,
could I respond? This John Summers.
Mr. Summers, if you want to answer it, I just want someone to tell me what the community is thinking out there and where the balancing act is.
First of all, from the pictures that Ms. Nickens has supplied to me, and I've driven by and taken a look, I question whether or not there's been that level of investment there. But Mr. Bars bought the property from Mr. Ramsey. And so I would say his rights really to recover go against Mr. Ramsey in terms of representing the property was out there. I serve on the Planning Commission. We're always told that, these decisions are not supposed to be made on economic issues. As an investor, this is a free market system. You take your chances, you bet your money, and sometimes you win and sometimes you lose. But, what's happened here is that the neighbors have had to come in to get proper enforcement of the zoning code and what they believe the zoning code to be. And so, our position is that Metro government owes a duty to everyone in this community, and that your zoning administrator is now telling you that he improperly issued this permit. Mr. Barr can take his remedy against either Metro government or Mr. Ramsey, whoever he chooses to do so. But that was a speculative investment on his part. And he's been on notice for a long, long time, as Ms. Nickens said, that he was investing at his risk. He was putting more money into it at his risk. And quite frankly, I think it's pretty clear, you're an attorney, I'm an attorney. They're going to try to, say that they had a vested right in here. As they pour more money into the project, even when they were told that there was an issue.
Thank you, sir.
Any other questions for the applicant? All right, seeing none, I was just informed by the code staff that I do believe we have a caller, and based on what we've heard before being, I think, a little bit of a time lag, I'm not able to see exactly what the public's able to see. And so I think it's probably best that just for the sake of having everyone heard in this strange COVID call-in meeting, that we hear this caller unless there's objection from the board. As all the callers have, I think they have a minute or 2 minutes. There's a time limit, Jessica can tell us. But is that true, Jessica? We do have a caller on the line?
We do. We're going to get them transferred. Give us just a few seconds. Hello, caller. If you'll start with your name and address.
My name is Laura Mitchell, and my address is 818 DeWeese Avenue, Nashville, Tennessee, 37204.
Okay, and tell us why you're calling today.
I'm calling. I work for Rudy Title and Escrow. We conducted the real estate closing on this property. Mr. Bars filed a title claim, and while reviewing the title claim, I noticed the appeal that had been filed, and Soraya Kashani's name was listed as possibly residing in the home. I am personal friends with Soraya Kashani and texted her and asked her if she lived in the home at 4109 Murphy Road in 2017. She responded with she lived there in 2002 through 2005. I also spoke to Ms. Kashani today. She's in Colorado and available for call if that needs to be verified.
Okay. All right. Are there any questions for the caller? All right. Well, thank you very much.
Thank you. Bye-bye.
All right. Bye-bye. All right. I believe everybody's time is up, so I will close the public hearing. And of course, board members can ask questions of the zoning administrator at any time. And I'll start with a question to Mr. Michael. And, you know, I guess, you know, we have a big case file, a lot of information. We've heard testimony from both sides, and ultimately this case is about whether or not you are, and when I say you, it's you and or your staff, because we know that sometimes these decisions are not made by you personally, but based on everything that you've heard, do you still have the same opinion that you had when this case first started, saying that had the information that we've seen today been presented to you or your office at the time the permit was issued, that in fact the permit would not be issued? Have you seen anything or heard anything today that would change your mind on that statement you made at the beginning of the case?
No, it would not change my mind. I still hold the same opinion from the beginning of the hearing today.
Okay. Ms. Davis.
So, Mr. Chairman, I'll defer to you. I don't know if you had any more comments. I'll wait until you speak to share my perspective.
No, please share your perspective.
I think this is a really tough case. I'm sympathetic to both sides. I guess sort of where, and I'm still listening, so I'm open to the wisdom of everybody else, but sort of after reviewing our packet and listening to the evidence today, from my perspective, the weight of the evidence sort of tips in favor of the applicant. We have a statement from the zoning administrator that says that this permit was issued in error. It seems like this permit would have never been issued had the neighbors not come forward with the evidence that they had, saying, hey, this wasn't used as a duplex. I've seen plenty of homes that are single-family zoned that have mother-in-law quarters, and that didn't change the zoning use. It didn't change it into a duplex. There's a lot of single-family zoning out there that have mother-in-law quarters, and it seems from the evidence this was never permitted as a duplex. And given the sophistication of the parties, particularly the opponent, it's sort of hard for me to make the leap that even despite the significant investment, which I do think is unfortunate, this was never, that use of a duplex was abandoned a long time ago, and that's evidenced by the fact that it was never permitted. So just because I don't think any of the personal information that was offered is relevant. I think the only thing that's relevant was this permitted as a duplex? And if it wasn't, when was the use abandoned? And it doesn't seem like just because somebody is living in a part of the house or they never turned off the electrical part of that house doesn't mean that somehow means that it remained a duplex. And so from my perspective, at this point, and I'm still listening, I'm willing to support the applicant.
Okay, Mr. Wallace?
I do have one question, and I guess it's going to be directed more towards our lawyer types. And that is, we heard from someone over at Rudy Title that there's a title claim pending were they given notice, and are they entitled to notice? Because they would at least indirectly be either a third-party beneficiary of how we vote or not. And I don't have an answer to that question, guys.
I do, Mr. Lawless. This is John Michael, the zoning administrator, and the Metro Zoning Code requires that the notice be sent out to all individuals or entities that own properties within X number of feet of the subject property. So those who have other claims would not necessarily be included within that, but could be if it so happened that one of the entity or an individual owned property within the, I believe it's now 1,000 feet, used to be 600 feet of the subject property. So most directly answering your question, no, there's not an automatic entitlement based upon a separate claim.
Okay. I just want to make sure that I don't think this ends with us, I guess is where I was aiming mine. So I'll leave it at that, and then I'll trust your judgment on that, John Michael. Thank you, sir.
Okay. Any other comments or from the board?
Sure. This is Mr. Pepper. I tend to agree with Ms. Davis, and I think it's unfortunate for whatever amount of money that the developers put into this, but you can't be too careful when you step into a situation like this. You really can't do too much due diligence about what came before and whether there's been a cessation of use, because we've had this occur where in the past where, people have bought properties and because there have been 2 meters, they assumed it was a duplex and then they found out it wasn't. In terms of I want to address the vested right argument. I will say it's been a while since I looked at that vested right statute, but there's no way in my mind that it means that if Metro issues a permit in error, then that cannot be undone. And I think that's essentially the argument that's being made. And that's, in my mind, the vested right statute doesn't, as I remember, it doesn't concern the issuance of permits. It concerns enactments of zoning laws that affect a property. Those are my thoughts on it. Thank you.
Okay. Yeah, and I'm not, this is David Taylor again. There was a question raised about whether or not it was ever truly a legal duplex, and we didn't really go down that far, that argument very far. And I don't know that I could speak to that. I mean, I don't, my thinking on this has more to do with the use and whether or not it ceased the use. And, to me, the last caller raised a little bit of question about Ms. Chambers, who was the owner from 2002 to 2007, about her claim, but it also, it hasn't really addressed, I don't think there's anybody has presented evidence that the Eastgates rented or had other people living in the home besides themselves. And, it just is I think it's a 30-month window. So I tend to, I think, agree with Ms. Davis and Mr. Pepper's comments, at least at this point, especially given the fact that the zoning administrator himself, who's by definition, this is an item A, saying, did the zoning administrator err in issuing the permit? And the zoning administrator said, yes, I did, based on the information. So if nothing else, that to me is probably the most compelling testimony, and that came from the code staff themselves. So, Ms. Carpenter.
I don't have anything new to add, and I agree with all three of you that have already spoken. So if someone would like to make a motion, I would second it.
All right.
I'll make
I'm like you. Yeah. I'm like
Davis.
I make a motion that in this case, the zoning administrator did err in issuing the permit in this case. And based off the weight of the evidence, including the testimony of the zoning administrator, the applicant's appeal should prevail. And I think I badly worded that, y'all. So if somebody else wants to take a stab at it, please go ahead.
That makes sense to me. That the motion is that the zoning administrator erred and for those reasons. Ms. Carpenter.
I'll second that.
I have a motion and a second. Now, any further discussion? All right, seeing none, we'll call the question and ask for a vote. Ms. Davis?
In favor.
Ms. Carpenick?
In favor.
Mr. Cole?
In favor.
Mr. Newton?
Favor.
Mr. Lawless?
In favor.
Mr. Pepper?
In favor.
And I'll vote in favor also. That motion passes. And now we will hear the next case.
The next case to be considered is case 2021-020, located at 36 Green Street, requesting a variance from minimum lot size requirements within an R6A district to build 2 single-family residences. Here's an overview of the parcel's location, zoned R6A. The aerial view of the surrounding neighborhood. Here's the proposed site plan for the 2-unit development. Existing conditions, surrounding area, and the property across the street. The applicant may now address the board. Please state your name and address and present your case. And at this time, we also do invite members of the public to call into the telephone number scrolling across the screen to voice your support or opposition to this case.
Hello, my name is Warren Sawyers, 3032 Cody Hill Road, Nashville, Tennessee. And thank you all to the chair. Thank you for your consideration, and the board members, thank you for consideration and for allowing more time to get involved in the community. I really enjoyed the process of reacquainting myself with several people in the communities in which I played and grew up, in this case and the one that's coming after this case. I'm somewhat intimidated by the previous case because I'm not an attorney, and they seem to be so very well versed in the technical sides of these appeals. I'm just a guy that grew up in these areas, but I do, and I am very, I care about this community and these communities, both of them. Yeah. I submitted to you all presentation to kind of bring you closer to the community. I felt like the last time I spoke to you that it was somewhat distant because of this not being able to see you visually, not being able to be there in person, and not being able to express my passion for the community. And hopefully, if you read the presentation, that does come across a little bit better. Now, this is not Sylvan Park. This is Napier, J.C. Napier, and we have a hard time getting people to live in this community. So what I've been doing over the last 14 years is trying to help the community and help the people in the community and give them housing that you can be proud to live in. And if you went to that presentation, you would see how some of the people are living, and you'll see the picture there of the unit to the left of the proposed site, which is one of the homes that we've built over there. And we plan to build similar type units there. You guys gave me additional time to get community support, and at this point, we've got more than 32 letters of community support representing over 41 parcels in the area. Growing up in this community, Mansfield Douglas III was the council member, and Mansfield Douglas would always call you back, and he would even welcome you to his home, have a folk with you, and talk about what was going on in the community. It doesn't seem like it happens anymore. And there's a lot of reasons that people tell me it doesn't. I'm not going to go into that unless you guys really want to hear what people have to say. But, my mother would always say, don't say anything unless you got something good to say. So I'll leave it at that. But we are looking for a lot size variance. We think that the narrowness of the lot does meet the description of the narrow hardship that's listed in the documents that were sent to me. We know that the board consideration can be given to the characteristics of the neighborhood and the way it was developed. We think we also fit that criteria, given that there are a cadre of different lot sizes. We have houses on 1,560 square foot lots. We have a house on a 1,988 square foot lot. We got houses on 2,300 square foot lots. The board has also approved
2 minutes remaining.
How much time?
2 minutes.
Okay, thank you. The board has also approved, several, that's in my presentation. Hopefully you've had a chance to look at that. At least 4 different projects in the area that were equal to my requests, or actually they had lesser square feet, more units on lesser square feet. So I included that as well. So I think I'm asking that the board approve based on the lot size narrowness, the neighborhood characteristics, the 32 letters of community support, 3.75%, which is well under the 5 and the 10 that is usually debated from the many minutes of tape that I've watched previous hearings, and the prior approvals of equal or lesser size lots. I am willing to make any amendments as the trees that Mr. Pepper talked about last time. We are going to put trees in our plan, and any other accommodations that the board sees fit. Look forward to you guys supporting us in this.
All right, thank you, Mr. Sawyers. Are there questions from the board, Mr. Lawless?
Just if I could, what's the price point that you're looking at for these dwellings?
The price point?
Yeah.
To build?
Yeah, to build. I mean, just ballpark it. I know this is not to try to keep you in any way, shape, or form, but I'm aiming towards affordable housing, I guess, more than anything else.
We think we can build somewhere between 200 and 250 a unit.
Thank you, sir.
Any other questions for Mr. Sawyers? Ms. Carpenter?
I don't have a question, but I wanted to say we did receive your presentation since you mentioned it a couple times, and it was nicely done. And I think we're all sorry that we can't see each other.
All right.
Heard what you were saying and just wanted to acknowledge it.
Thank you so much.
You're welcome.
Okay. Any other questions? All right, Mr. Sawyers, anything else to add?
If there are no questions, no. No, thanks.
All right, thank you. We will close the public hearing. And I know that the first time we heard this case, we had asked Mr. Sawyers to go and solicit some community support, which he's certainly done in our packet. We'd also ask him to talk with his council member, and there's, in my mind, ample evidence of him making those attempts to contact and share with his council person what he was trying to do. And so I think that certainly the councilman has had every opportunity to weigh in and has chosen not to, which is certainly his right. And in my mind, he's done everything that we've asked, and given the 3.5% difference and the nature of the neighborhood, I'm inclined to support the variance, but happy to hear what other folks have to say as well. Ms. Davis.
I was just going to say, Mr. Chairman, I definitely understand your rationale and perspective on this, and I just wanted the record to reflect that I won't be voting in support of it. I do think the applicant did a great presentation, but I do think the council member, even though he didn't weigh in on this particular case, he sent us sort of a map several cases ago in this area and sort of warned us that, sort of to kind of a forewarning of, like, if you do this, there are a lot of other homes in this area that are of similar makeup, and that he didn't necessarily see a hardship warranting the variance, but that, he essentially gave us the discretion to decide. So I think we've seen a lot in this neighborhood. I think we're gonna see more. I feel like he has weighed in, and there's probably too many to kind of weigh in on each one. I think this lot, there's nothing unique about this lot to warrant the variance. I do understand the percentage that people use, and I understand the logic, and so I definitely respectfully disagree, but I understand that perspective, and that's it.
Okay, great. Other comments? Ms. Carpenter.
I will support the variance request. I do think it's a small amount that he's asking. And the property is zoned for 2 family dwellings on it. And to me, the hardship is just that the size of the lot is just a little bit smaller than what it would need to be in the bulk regulations. And I think we're allowed to look at the way the neighborhoods are developed, and this neighborhood is developing into a neighborhood with two on one lot, given the fact that it's an R6A zoning.
Okay, Mr. Newton.
Yeah, I think I would tend to agree as well. And when you get down to that, 200 square feet, that could easily be, especially with a neighborhood as old as this is, that could really get down to a surveying error. Especially when the lots are somewhat orthogonal, but kind of, but they have an alley in the back. I mean, that 226 square feet could literally just be due to the alley in the back. So, I would be inclined to support this variance request as well.
Okay, Mr. Lawless.
Now, I remember when this came before us we had some discussions about trees and items like that. And I think that my good friend, Mr. Pepper, being the horticultural expert that he is, did discuss those matters. Ross, you want to weigh in here? Because
thank you, Mr. Wallace. And the applicant agreed, as I recall, or was willing to obtain the variance. I can't remember the number of trees and where the applicant could put them. If we could, Mr. Chairman, if we could open the public hearing back up to hear from the applicant about that, that might be helpful, because I think I sense a motion coming, and I think I would want to make sure that we could amend it, if possible, to take care of the trees.
Okay, I will open the public hearing and ask Mr. Sawyers to remind us what we had committed to, or what he had committed to on trees, and what his thoughts are there.
Yes, absolutely. I did mention that in my remarks earlier, that we do plan to put 2 or more canopy trees, and we'll talk to someone that's more of an expert as to where they can be placed within the plans that we have, to make sure that we have 2 or more canopy trees.
Mr. Lawless?
Could we have the Metro Forester maybe do some discussions on what, and just make it subject to that type of approval? Because, I mean, there's not a whole lot of green trees. I mean, more of them are getting cut down than are getting put back up. And I think everybody on the board knows how some of us feel about having those things growing. It improves the quality of life for all of us.
Sure. Any more questions for Mr. Sawyers? Okay, I'll reclose the public hearing, and then Mr. Lawless, how about a stab at a motion where we approve the variance for a minimum lot size based on the age of the lot and the 225 square foot difference that the closeness of the percentage being off, and age of the lot in terms of within a margin of error for a survey, and that variance be contingent upon the applicant planting at minimum 2 canopy trees, but also working with the urban forester to appropriately landscape. I don't think that, based on the picture, I don't think there's a tree on there on the lot now, but to work with the urban forester to appropriately landscape the property. Is that?
I think that's great. It allows enough of to permit the homeowner or the property owner to work with it, but also I think accomplishes what everybody keeps hearing from Mr. Pepper and myself. We like trees. So
is that a second?
That's a second.
All right, there's a motion, there's a second. Is there any additional discussion? Seeing none, we'll call the question and vote. Start with Mr. Lawless.
In favor.
Mr. Pepper.
In favor.
Mr. Newton.
In favor.
Mr. Cole.
In favor.
Ms. Carpenter.
In favor.
Ms. Davis.
Against.
And I'll vote in favor. That motion passes. And
I thought my motion was going to help bring Ashanti over to us.
No.
Nice try. Next
I'm gonna say we'll let y'all keep working on that one.
I understand.
So, and I think we're down to our last case today, which is case 21, which is also Mr. Sawyer's case, and we'll hear first from Ms. Minton to present the case to us.
Final case 2021-021, located at 1911B 10th Avenue North, is also requesting a variance from the minimum lot size within the R6A district to construct 2 single-family homes. The zoning map showing the location of the R6 zone parcel and overhead of the surrounding area, the proposed development, the existing site, and the surrounding areas, and the property across the street. The applicant can now address the board by stating their name, address, and presenting their case.
Warren Sawyers, 3032 Cody Hill Road, Nashville, Tennessee. Again, I appreciate the opportunity once again is to go out into the community. This community is really special to me as well, as I exhibited some different things in this presentation than that were different than the first presentation. I guess one of the first shots was the home I grew up in until I was about 4.5 years old on Delta Avenue, which is 2 blocks over in Jones School. And during the time from the last time we met, you guys may have noticed that this neighborhood is 37208, and it's considered the highest incarceration rate in the country in this zip code. And so that it kind of brings up different emotions in me to think about this neighborhood. It is changing. It is somewhat being gentrified at this point, but there are still a lot of people there that remembered my grandmother, some people who I talked to. We've got 50 plus letters of community support here, representing almost 70 parcels in this community. So we really had a lot of good conversations. The neighbors, when you look at the house, the neighbors to the right, they're excited about what we're doing there or want to do there. The lot is unusually narrow. Mr. Pepper had asked last time, were there a lot of 50-foot wide lots? I didn't have the answer, and the answer is yes now. I know the answer to the question now. But there are also some lots smaller than the one we're looking at. One of the pictures of the lot that's on the corner is approximately the same size. You would see that in your presentation if you have it. It would be the one that's the 1925, which is the front facing 10th, and 1924, which is the rear, which is facing Orange Street. And so there are a lot of double units in the community. And I think 10th and Orange is unique because they do a lot of houses in the front of each street. So it's not an alley. So each house does face the street. We believe that we have a very unusually sized lot, but we can put 20-foot or 22-foot wide and still meet all the requirements without asking for any additional variances. So this particular request is for the light size variance. We do believe that our hardship is somewhat different than the other ones because we are a 28-foot wide lot there. But the front and back makes it, I'm sorry, 32 foot lot. But the front and back makes it unique that each particular home will face a street. And I think that's what makes this one a lot different than some of the other ones there. And the community. Okay, and the community is looking forward to this. The community does think it would improve the community. As you can see, we can make it, we can clean it up. We will, in our plans, we haven't bought house plans yet, so it's really going to be helpful on this one and the previous case to sit down with that forester and say, hey, how can we build and put these units there maybe somewhat differently, if possible, than the plans, but make sure we get those trees in there. So that's important, and it's important to all of us to get those trees in there. And so we do request your approval of our request. Thank you so much.
Okay, are there any questions for Mr. Sawyers on this case?
This is Mr. Pepper. I have a couple. Mr. Sawyers, have you done the math? I think I had it last time you were before the board. What is the percentage that the 560 square feet is short? Do you know?
What percentage? Yes, put it in that presentation. Let me get exact this time because I hated I couldn't answer your question last time. That would be, it's under 10. I know that's important to you from listening to your other cases, and it is, I think it's 8, let me get exact here, 9.3.
Okay, and unfortunately, because my internet connection is gone, so I'm having to do this just by telephone. Are the adjoining, there's no alley on these properties. Is that typical of the neighborhood, or are there adjoining streets and blocks where the homes do have alleys?
There are some streets where the homes have alleys. If you look at the BZA, you will see where the homes that have alleys, typically they are putting up HPR side by side, and they're having rear entrances. But since Owen and 10th is one of the few that that both are streets, you're going to see the front and back. And in my presentation, I tried to take you through the neighborhood so you could see the differences in the front and back. I actually showed you, just actually traveling down the street so you could see the front of the units on 10th and then see the front of the units on Owen. So the Owen neighbors are like, hey, we're looking forward to have somebody, when we walk out the front door, we'll see them. So to answer your question, this one is somewhat unique, but there are alleys in a lot of the other streets. For instance, the house I grew up in Delta, it has an alley back there. But also on that Delta drawing, you would see it also had a house in the back, and that house was there in 1950. So that kind of tells the community is an older community. 1930 is when many of the houses were built in that 1930 section. So they were putting houses in front and back, even though we're looking for two houses to face the street.
Okay, and then the same question about, again, I'm at a disadvantage here because of my internet being down. Same question as to the frontage. These properties this property has about 32 feet of frontage. How does that compare to the other properties on the block and or across the street, or across both streets, I guess? Can you tell me how unique is it in terms of it being only 32 feet in width compared to the surrounding properties?
Okay, that particular property is 32 feet. The one that's to the north is about 40 feet wide. And they just park on the other side. So they have front parking and they park on the side as well. The lot to the south is I think it's about 22, I believe. I believe that one's 22, the one to one to the south. So there are a lot of different size lots there. Not as many as the South Nashville we did, but there are a lot of different size lots, and many of them are 50. They go down to as small as 28 that I saw. But I think the neighborhood is structured a little bit more differently than the one that we talked about previously. But you'll see, as you can see the overhead, I'm sorry you can't see it, Mr. Pepper, but you'll see that there are most of these lots, that the community is going more to two units on a lot. So it's nothing unusual as the previous case was. Sylvan Park is trying to keep that out. I think that there's very little community resistance for putting up 2 units.
Okay, thank you, sir. Appreciate it.
Yes, sir.
Mr. Lawless.
Okay, and again, we're going to go back to the trees and the green plantings and what have you around. Are you willing to have the same phraseology that we had on your previous one with working with the forester? What type of coverage are you looking at? Because this lot is a little different than the other one.
Actually, yes, I am. So that's the immediate answer. I like to get a recommendation from those of you who know the urban forester. I like to get their information. I like to talk to them about how we do that before we put the house plans in place. As I mentioned earlier, and in the previous time we met, I'm not opposed to making changes. We haven't paid for any plans. I've got some plans that we can use, but we can actually work around the trees. I think that's a good thing. I think it does help bring a different beauty to the neighborhood, and that's important to me. And as I said, this neighborhood is important. I noticed there was a case on the previous time we met that there was someone who was really being an advocate for trees. I heard her, and I want to make sure we're doing that as well.
Thanks, sir.
Any other questions for the applicant? All right, Mr. Sawyers, did you have anything else to add?
Not at this time.
Okay, and with that, we'll close the public hearing. And thoughts or comments from the board? Ms. Carpenter.
I can see from the parcel viewer that this lot is a bit narrower than other lots in the area. So I would be willing to support this variance request for that reason.
Okay, Ms. Davis?
So the last case, I definitely understood the rationale for a variance, given that it was only 3.5% and the kind of past precedent. This one is like 9.3%, which is nearly 10%. And I guess, I just want everyone to know, as nice as this presentation is and the context, I just, these cases set a precedent. They don't happen in a vacuum. And I think you open the floodgates to someone coming in who's a couple houses down and it's like, oh, I'm only 12% out, or I'm only 11% out. And I guess my concern with approving this one is just, I've said this before, and I really like saying it, so I'm going to say it again. Certain horses aren't made for certain courses. Maybe this horse ain't made for this course. And so I have a hard time supporting this, but I understand that I'm in the minority and that I'll probably be the only vote. But I just wanted that to be on the record and the record to reflect that.
Okay. Mr. Newton.
Miss Davis, you're making assumptions here, because I kind of agree with you. I see this. I don't know, I'm having a hard time with this one because I see that Owen Street is its own street. I know that one of the neighbors wrote into us and talked about how it was essentially an alley, and I think Mr. Pepper asked about that, but it does show up as a street, and it does have a few houses fronting it. But definitely the original development pattern seemed to be more onto the 10th Avenue and 11th Avenue. And I know that neighbor was worried about traffic on an understandably narrow street. even though it is a street, but if it functions more like an alley. So I do have some concern there, and I do tend to agree with Ms. Davis here. This is kind of pushing it, and just looking at the parcel viewer, there's really, I mean, this is the second most narrow lot on the street, on the block, on this side of the block, or on either side of the block actually, and the narrowest lot is next to it. And I mean, just quick calculations, this and that other one would be the only ones that would really be outside of that 6,000. There's some that are really close on it too, but they're going to be 10+% or 9+% lower. So I'm having a hard time supporting this one. But I do really appreciate the applicant's work to put this presentation together. I think he did a great job of presenting it. But I tend to lean towards this is not the appropriate use here.
Ms. Davis, did you have your hand up again?
Yes, I just wanted to apologize to Mr. Newton for making an assumption, and it's right. And that's sort of what tipped me over to was the opposition email. And I think if I remember back a couple of years ago, we had another one that appeared before us, like in this area where someone made sort of similar arguments about Owen and how it essentially is an alley. And I remember that case as I was looking through the presentation. And I'll stop talking now. Thank you.
Well, and I tend to, I think this is a tough one either way, because I do think, the presentation's good. I think that the neighborhood is, at least from the visual we're seeing, is clearly going multifamily, but it also is a very narrow lot, and it's really on the, very outskirts of the limits that we've approved that I can remember. So I don't agree, or I don't think that it's a slam dunk one way or the other, really. But I'm having a tough one too. Mr. Lawless.
Well, I want to compliment Ms. Davis. She did a better job of dragging someone along with her than I did on the last one, because while at the beginning I was more in favor, it is at the top end. Actually, it's a little bit over in the percentage that we have in the past, or that we've sort of, okay, we can go with. So I'm going to make a motion, if I can, Mr. Chairman.
Of course.
To deny the request as presented.
Okay. There's a motion. Is there a second?
This is Ms. Davis. I second.
All right. There's a motion and there's a second. Any discussion?
Yes, this is Mr. Pepper. I agree with I think everybody that's spoken so far that it is a tough case. I mean, I think 10% is a reasonable line for us to draw, especially when you're talking about lots that were platted out back in the early 1920s when measurements just weren't as exact. I'm at a disadvantage today because I've lost my internet. I mean, and I can't look at the parcel viewer. So from what I'm hearing, this property is unique in that it is the second most narrow lot, meaning it's got, less frontage than most other lots on that block. And I understand how it being narrow concerns the board because of the parking issues, but it's kind of a double-edged sword to me, because it seems like it also cuts towards it being the hardship being that it is exceptionally narrow. So I'm really on the fence right now too. Before I vote, I would, if there is any more discussion or insight, I would appreciate it, because I really think that there's it is unique in that it's the second most narrow lot apparently, and yet I also think it is really bumping up against where I've always been comfortable. And since I've been on the board, we've kind of, seems to me, collectively been comfortable. And so if anybody else has anything to add to that, I would appreciate it, because I'm literally right on the fence on this, and it would be helpful for me to hear more from other board members.
Ms. Carpenter.
Well, I agree with you, and I realize you can't see the Metro GIS, but it is showing as a more narrow lot than many of the others surrounding it. Not all of them, but many of the others surrounding it are wider lots, and so they have that right to place two dwellings on one lot. And I'm seeing this applicant as not having the same rights of his neighbors because his lot is narrow.
Mr. Newton.
Yeah, I keep going back and forth in my mind. But, you know, just for Mr. Pepper's benefit, it appears that most of the lots along both sides of the street were originally platted at about 50 feet wide, and both this plot, or this one, along with this lot, along with the lots to the north and the south of it, were originally, and there's a kind of on Metro's viewer, there's kind of a faded line there. It looks like it's an old property line. It looks like it was originally 2 50-foot lots, and then those have been split up into 3 lots. And in this case, it's got a 40-foot lot, a 32-foot lot, and a 28-foot lot. And then across the street, it appears they did the same thing, but those are all equal at 33 1/3. So with that all being said, it's the second smallest lot on either side of this block face. But I also do understand the argument that this property owner is not getting something that all of his neighbors are getting, but he's also has a much smaller, a somewhat smaller lot than his neighbors have. So I'm going back and forth on this one in my brain, to be honest, and I appreciate it if anybody else had any thoughts.
So this is Mr. Pepper. Ms. Carpenter, do you view this as being so narrow that it's unique enough that presents an adequate hardship? I think that's what you're saying, and that's what I'm concluding. Okay, thank you. That's
yes.
helpful.
That's what I am. And I'll also add that it's zoned R. It's not zoned RS. So others do have that right to put the two on one lot. This is unlike Murphy Road, which was zoned RS.
All right, so we do have a motion on the floor to deny the variance. It has been seconded. Is there any other discussion on that motion? Okay, so the motion on the floor is to deny the variance, and we'll call the question and vote on this motion. And start with Mr. Newton.
In favor.
Mr. Lawless?
In favor.
Mr. Pepper?
Against.
Ms. Davis?
In favor.
Ms. Carpenter?
Opposed.
Mr. Cole?
Opposed.
Oh, Lord.
That's why you get paid the big bucks, David.
Yeah, that's right. Sorry about that, gang. I was hoping you all would decide this for me. I'm really torn, and I think on being torn, I'm going to vote in favor of this motion. And if the neighborhood changes and the owner can bring us back something different in the future, certainly would reserve his right to do that. But I think to me, it really is just kind of pushing the limit in a way that I'm not comfortable with. So I'll vote in favor of that motion also. So that motion passes. And I believe that's the last case. And with that, I think we're adjourned unless there are any other comments from the board. Mr. Lawless.
Just a point of inquiry, and this might be better to ask for John Michael than anybody else's. Short-term rental group, are they officially up and running, John Michael?
The short-term rental board is up and running, and they will have their first scheduled meeting next week.
Fantastic. Thank you.
You're welcome.
All right. If no other business, then our meeting is adjourned, and we will see everyone shortly.
Bye-bye. See you all next week. Or
all right. Bye, everybody.
Bye, everybody.
Bye. Thank you.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.